Good afternoon, everybody. I'm going to give it a few seconds to allow the attendees to log in, and then we'll start the program. So just hold on for a couple of seconds, a couple of minutes, a minute or so. Well, thank you for everyone holding on. Good afternoon. This is Daryl Gay. I'm a partner at the law firm Aaron Fox, a member of the college, and I'm welcoming you to this day's program. If not affirmative action, then what? The college is pleased to bring this program on. We have a very stellar team to present to you. Team typically, as you know, the college likes to include the different perspectives on the issues. So we have people from the plaintiff side, the union side, DEI specialists, manager side. So we're going to have a very engaging conversation. Let me introduce the speakers. I'm just going to give their names and their titles, and I welcome them to be able to indulge upon that. We have a guest speaker, Alfonso David, who's the president of Global Black Economic Forum. We have Gene Lee, who's the president and CEO of the Minority Corporate Counsel Association. We have Joseph West, who is the DEI officer and a litigation partner with the firm Dwayne Morris. We have Carl Levine, who is a partner with Levy and Ratner. And we have Nina Peruti, who is a partner with Garrison, Levin, Epstein, Fitzgerald, and Perotti. Nina is a union attorney. Carl is actually Carl is a union attorney. Nina is a plaintiff lawyer, and Joe obviously is a DEI specialist for his company as well as a litigation partner. I am a management lawyer. So having said that, we want to spend some time today talking to you. The topic is affirmative action, and there's been a lot. In fact, those who follow Employment Law 360 probably noticed there was an article yesterday about a major law firm being sued over its DEI policy. So we're seeing more and more activity in the space, and there's a lot of confusion about what this is all about. What is affirmative action? There is a lot of mythology out there about what affirmative action, suggesting it is something that it is not. Historically, if you look things up, you see one of the earliest terms in affirmative action was used was relative to the Wagner Act when it was first created, with affirmative action being an initiative to ensure guys who supported union activities were not denied opportunities to work. So that's what affirmative action really was meant to be, an opportunity to address the intent of people discriminating, to make sure they were not discriminating, but giving opportunities. That's what it's about. Many today are suggesting that affirmative action and all of its progeny things, DEI, all about providing opportunities to people who are not qualified, to the denial of opportunity to people who are qualified. That is so far from the truth, it's unreal. As somebody who grew up during the affirmative action early periods, from the early 50s, 60s growing up, I constantly heard about this affirmative action thing and the 10% set aside. Never saw anyone ever get the 10% they talked about. Usually saw that the people who were chosen were usually 2 to 3 times more qualified than the competitors. Affirmative action never related to giving people less qualified the opportunity. It related to giving companies, making companies an opportunity to pay attention to not engaging in discrimination. Companies engage in refusal to hire, promotion, other opportunities of employment, and when they created the Civil Rights Act in 1964, a lot of companies actually took steps to try to avoid being sued by individuals like Carl Levine and Nina Peruti for violations of the law. A lot of companies took initiatives to try to make sure that companies were not engaged in discrimination, were taking initiatives so that their companies would not be sued. A lot of that is what is affirmative action when it came out. Title VII and executive orders promoted companies taking initial steps to avoid discrimination, not engage discrimination. Unlike education law, employment law has never permitted people to utilize a social classification as a factor in hiring or any other aspect of employment, unless the company was in fact demonstrating they had in fact by a disparity study otherwise had failed to properly represent the people coming in this company. There have been multiple studies over the years that have shown that, in fact, despite Title VII, despite affirmative action, despite DEI, companies have engaged in discrimination. There have been studies showing that a Black man without a criminal record has less likely a chance to get a job than a white male who has a criminal record. A recent New York Times study that I think is in materials that was just recently, the study was just done, and it was in the paper just recently, pointing out that they did, I think, 80,000 resumes out to 1,000, 10,000 companies, and they demonstrated that a black male has less likelihood of getting a job than a white. And it's still a reality that discrimination still exists in employment, and therefore it's still necessary to deal with stuff. Uh, but workforce DEI also, there's also been studies showing that DEI actually works for companies. It helps the companies with its workforce, creating a better culture of workforce. It works for companies relative to their ability to relate to their customer bases. And it permeate the fact that discrimination still exists in the workplace means we still have to do something. So the question then is, what do we do? So we're going to spend some time today discussing what this Students for Fair Admissions case has done to impact the whole idea of employment. We've got a stellar audience. We're going to start out with Alfonso David, who has been very actively involved in a lot of the litigation that has come post the decision. Alfonso?
Thank you, Daryl. Good morning, good afternoon, everyone, depending on where you are. I think as we take a step back on the affirmative action decision, we're close to about a year since the decision was issued. As you know, that decision challenged the education admission policies at both Harvard University and the University of North Carolina. And the court ultimately concluded that race could not be used as a sole factor in determining admissions into those two policies, or as it relates to those two policies. That decision, of course, has been interpreted to apply writ large to colleges and universities, and many colleges and universities have modified their admissions policies as a result. After the decision was issued, we saw quite a significant impact in a number of different spheres, and I'll talk about them individually, and then I'll briefly talk about 2 or 3 cases. The first is, I think, education, of course. Litigation post the Harvard UNC cases continue to challenge affirmative action related policies in colleges and universities. As you know, that case focused specifically on race as a sole factor in determining college admissions. Nevertheless, what we've seen is post the affirmative action decision, litigation nevertheless has continued. There's 2 meaningful points as it relates to the affirmative action decision in the education sphere that are worth highlighting. One, the Supreme Court recently rejected a petition for certiorari for the Thomas Jefferson Magnet School. This was a school in Virginia that essentially had a policy to try to diversify the student body, and they were challenged, and the court rejected a petition for cert in that case. We can read the tea leaves and try to understand what that meant, but I'll leave it up to you to do that. The second is the court rejected an application for cert in West Point. As you may know, in the West Point case, the court essentially did not apply the affirmative action ruling to West Point, carving out West Point as in that case. And so there was a challenge to West Point's policies, and the court denied cert in those cases. Now, anti-affirmative action advocates have challenged those programs, arguing that they're no longer lawful under the court's ruling, but the court has denied cert in those cases. Second category is public contracting programs. Government agencies and minority and women-owned business programs have faced legal attacks as well. As you may know, MWBE programs, as we often call them, were created to address long-standing and systemic barriers in contracting. Even though minority and women contractors accounted for 30 or 40% of contractors in some states, they only accounted for 2 or 3% of the contractors who were actually hired. So these programs were created and sustained based on what we think of as disparity studies, or we refer to as disparity studies. And nevertheless, the Small Business Administration's program was challenged, the Department of Transportation's program was challenged, and the Minority Business Development Program, which is embedded in the Department of Commerce, was challenged as well. And I'll talk about that case briefly. The third category is private charitable grant programs. So the Fearless Fund and the Fearless Foundation, 2 entities that I represent along with Gibson Dunn and a few other lawyers, was sued for providing grant programs to women of color, and specifically to Black women in one specific case. And then finally, I think private fellowship internship programs, law firms, as you know, have been sued. Other private companies have been sued for ostensibly seeking to increase diversity within their offices and within their industries. Some of those cases have settled, some of those cases are still in litigation. So that's the overall landscape that we're dealing with in terms of the general pockets. There are, of course, many cases that are still being filed. At this point, we've tracked more than 50 cases that have been filed in federal courts since the affirmative action decision, and more cases are going to be filed. And so we'll see. So let's briefly talk about the Fairless Fund. Fairless Fund is a venture capital firm that was started a number of years ago by two women who were concerned about the lack of investments in women of color businesses. And what I mean by that, the venture capital space allocates about $288 billion each year. And of the $288 billion, only 0.36% goes to Black women. So they created this company with the goal of trying to close this gap. And they found that they were being quite successful in trying to close the gap, and then they were sued. They were sued by an organization called the American Alliance for Equal Rights, which is an organization that was started by Edward Blum, the same person who was responsible for striking down affirmative action at the Supreme Court. And he argued that by providing grants to women of color, you violate federal law. He specifically focused on a statute called 1981, 42 USC 1981. And that statute was passed after Reconstruction to provide Black Americans an opportunity to contract. As you may know, during slavery, Black people didn't have the ability to contract or obtain an education or own property. And so 1981 was passed in order to provide Black people with the ability to do that. Edward Blum's theory here is that by providing grants to Black women or women of color or Black men, for that matter, based on this theory, you violate 1981 because you're excluding white people from being able to access those grants. We argued the case in front of the district court in September of last year, and we were successful in defeating a preliminary injunction motion. So the court denied the motion and essentially held that the American Alliance was unable to meet their burden. They filed an emergency petition. We ultimately ended up arguing the case before the 11th Circuit this past January. And we argued that as a charitable organization, because the Fairless Fund has a foundation that issues the grant, and the foundation as a charitable organization has a First Amendment right to issue grants consistent with their mission. You think about every other charitable organization out there that issues grants, and they issue those grants consistent with their missions. Why is it that in this case, you have a Black-owned organization, charitable organization that's providing grants to address a disparity in the venture capital space, and the argument is in that specific instance, they're not allowed to do it. So we're waiting to see what the ruling will be in the case. As I said, we argued the case in January, and we're waiting for a ruling from the 11th Circuit. We argued before a 3-judge panel, Judge Rosenblum, Judge Newsom, and Judge Luck, and we will see what happens in that case. The second case that I want to briefly mention is in the public contracting space, and that is Minority Business Development Agency. So in that case, another organization challenged the Minority Business Development Agency's law, which was enacted in the 1960s to assist business enterprises in overcoming social and economic disadvantages. And they argued that this program is unconstitutional because it denies opportunities to non-minorities. A Texas federal judge found that the Department of Commerce's MBDA law, which was again enacted in the 1960s, was unconstitutional. And essentially what the court said is, even though there is disenfranchisement of minority business enterprises, the court said that's beyond dispute, that there's evidence of disparities in federal contracting. In fact, the court, I think, referenced like 93% of the bids that are at issue in federal contracting. The court saw that there is a disparity for minority businesses. Despite that, the court found that the law itself is unconstitutional. And there were two theories. One was that it was under-inclusive and over-inclusive in the private context. The court held that the MBDA's interest in remedying the inequality was not compelling because it concerns private sector credit disparities. And the record shows that government participation does not really contribute to those disparities. In the public context, the court admitted that MBDA did not have a compelling interest, or I'm sorry, did have a compelling interest in addressing discrimination in government contractings, but the court found that it was not narrowly tailored. So the court essentially granted summary judgment for 2 of the 3 plaintiffs on equal protection grounds and permanently enjoined MBDA from presuming that certain ethnicities were, quote, socially or economically disadvantaged. And so that case, unfortunately, is at this point, it was subject to appeal. We're not quite sure what the government will end up doing there. And MBDA is still an agency that is ostensibly focused on providing support and resources to minority contractors. So, Daryl, I'll stop there unless there are additional cases you would like for me to reference.
So I will come back to you. Well, first, you mentioned 1981. My understanding is 1981 is being used by most of the challenges to law firms too. Am I correct about that?
Yeah, 1981 is being used not only in the private context in terms of lawsuits against private companies, but it's also being used against charitable organizations as well.
To a degree, a lot of the people on the phone are probably related to law firms. Do you want to give any commentary on the DEI activity in law firm cases?
Yes, most of those cases have been settled. There have been, I think we just saw King and Spalding, it was recently challenged. There have been 4 or 5 lawsuits that have been filed that have been publicly reported about, and many of those cases have settled. We don't have the settlement agreements in those cases, so it was difficult for us to surmise the basis for settlement. But I think in some of those cases, based on my conversations with folks who have been involved, those programs that have been challenged, in many cases, were being promoted or talked about in a way that was not consistent with how they were actually being enforced. So in some of those cases, the law firm settled because the programs were not being enforced in the way that they were being promoted. So, and again, this is fourth hand, so I don't want to suggest that those cases either had merit or the law firms settled them because they thought that the cases have merit, but instead they made a decision independently that it made sense to settle those cases.
Thank you, Alfonso. Just so the audience knows, if you have any questions, we don't have a question feature, we have a chat feature. So if you write your questions in the chat feature, I'll do my best to try to include those in discussion. Gene, you head up an organization that's probably the leading voice for diversity in the legal profession. And your board is composed of mostly corporate America. Could you share with us your thoughts on how these line of cases that Alfonso is referring to, and particularly the SFFA case, might have affected the the space that you may see oversee?
Sure, and thank you again for inviting me to join this esteemed panel, and thrilled to be here. Though the topic is not, as one said yesterday, I was talking to one of the in-house members, and she said, I wish there were DEI CLEs now in New York that are a little bit more positive, because all the CLEs about DEI these days are all the things we can't do to advance the goals and the mission of their own organizations to improve diversity, equity, and inclusion. So that brings me to the point that you asked about, which is how are corporations and perhaps even law firms responding to all these cases? And I think, Joe, I heard you say this as I was coming on for our panel. I mean, it certainly had a chilling effect. It's probably an understatement. I think that people are trying to figure out what's the reach of the law, and we ourselves have also been advised by one of the law firms who are leading in this space. As a nonprofit organization, we're not immune from that. So certainly I can I can see how this has impacted for large corporations that serve a global workforce as well as a global client base. Having said that, I think the biggest change I see in corporations is really more cosmetic in terms of how they talk about DE&I rather than what they're doing. I have not seen as much, at least for now, as much change in the work that they continue to do in terms of DE&I work. Now, have there been cuts? Yes, but have there been cuts in other spaces? Yes. Can it be possible that there are more cuts in DE&I because what's happened? Possibly. But just sticking to the facts of what people have shared and what I see, certainly, you know, some of the financial commitments, I know we've all read about them publicly, have probably decreased more for some than others, have reduced staff in some cases. Yes, that's happened as well. But certainly from a legal standpoint and the legal department, many continue to do that work. We do not see a significant waning of that commitment from corporations. And in fact, we continue to see, you know, a desire, anything from like our board level, a desire to get involved from a board level, from a committee level, advisory board. So certainly I see continued efforts. You know, if you were to say, well, how much less so, because that was one question somebody asked, I mean, probably about 20% of the companies are not as committed for a number of reasons, economically, financially, activist investors, I mean, you name it. I think it's a variety of things, but most companies are staying the course and certainly have continued to make that effort. But cosmetically, they've changed things like, instead of calling it the Diversity, Equity, and Inclusion Committee, they're calling it something else. Some people have called it People and Environment, Engagement of Excellence, and the like. So there's been some changes that are notable in that regard, but not as significant as I think people in the media and social media for sure is making it out to seem, at least from where I stand today.
So a recent conversation with a friend of mine who runs an international research think tank for CEOs and CHROs, he told me that majority of his member clients, which are mostly corporate America or corporate country companies, are not departing from what you call a DEI at all. They have standing their ground. Joe, you're a DEI officer for a major law firm, and prior to that, you were in the position that Gene held with MCCA. How are law firms responding? Is DEI still a valuable asset for law firms?
Daryl, thank you for inviting me, and I'm really thrilled to be with this panel. You know, there's one other role that I had that I think is instructive here, and that's before MCCA and before the law firm. I was this in-house counsel for 15 years, including 5 years at Walmart, a Fortune 1 that was a leader in the DEI space. And I mention that because the fact is, in the law firm world, especially large law firms, at the end of the day, everything is driven by client demands. And you heard Gene make reference to the expectations that still exist and will continue to exist in the corporate C-suite. And that's going to be communicated to firms. Now, what's happened, and Alfonso did a masterful job of laying out the litigation landscape. I think what's happened is, to the point I made earlier, and Gene echoed it, the chilling effect that's happened. Law firms have reacted consistent with basically where they were in this space before this opinion came down. If you had sort of a nascent to non-existent or a token approach to DEI, you saw it as an excuse to sort of, you know, overcorrect and not do anything. But those firms that had a meaningful approach to this issue saw it, and this is the case with our firm, as an opportunity to, the way banks undergo stress testing. Basically, take a look at what you're doing, make sure that it is consistent with the law as it now is, but continue moving forward with this. Because the fact is, there are three principles at work that will continue to have whole sway. First, as I mentioned, is client expectations. The other is there's just a certain demographic inevitability at work in society at large and in the workforce. There will be a need for diversity. There will be a need for equity. There will be a need for inclusion and inclusiveness. Diversity is about the workforce. Inclusion is about the workplace. If you're an employment lawyer, you understand the value of both of those things. If you are in the corporate C-suite, you understand the value of both of those things. And the fact is, law firms will still have to have an equitable environment and diverse perspectives and diverse individuals in order to do the work and provide the value that's needed for their clients. One other point I'll make is this. There are various choke points in the career lifespan where the existence of barriers to inclusion really have a contributing impact on attrition and the lack of retention and advancement opportunities. If firms will take a look at those choke points, whether it's in the recruiting process, the assignment of work, the evaluation of work, the mentoring function, even when and how and under what circumstances people are separated from organizations, and enact race neutral, race agnostic procedures, they'll have an impact on sort of eliminating the attrition that takes place that really has been to the detriment of diversity initiatives. And, you know, we'll have the opportunity to talk a little bit more detail about that. But firms that are serious about this will continue doing what they're doing because they have to, and it's in the best interest of themselves and their clients.
So, Gene, in the last, since MCCA was first created, and I remember that as in the beginning when MCCA got a lot of negative flack. In fact, Kathy Lamberley, who was a general counsel for Shell, got a lot of negative feedback because of her involvement in MCCA. How much has the landscape changed? And has it changed for the positive? I mean, how many in-house, have we seen an increase in the number of in-house counsel? And what has really been the impact on law firms, in your perspective?
Yeah, I mean, yes, I would say overall it's been more than super positive. It's an organization that really anchored itself in the research piece. Certainly, you know, my predecessors, Joe being one of them, Vita Richardson and Lloyd Johnson, the founder, as well as the board members at that time. I think you were one of the founding board members as well, Daryl. I have to think about that for a second because that was a long time ago. But certainly it has had a positive impact because I think, one, the research piece really educated people. I remember when I was in-house and Joe was at MCCA, it was the first organization to offer unconscious bias training. That was back in 2012. No one was really talking about that until I came here, which is around 2016, and people were asking about those. And by then, Joe and his team and a lot of the other folks within MCCA had already offered that training across the board. So it seemed odd that people were just becoming familiar with that when I remember being at JP Morgan. It was one of the best trainings that we had because it was interactive, it was engaging, and it really taught people a lot about how these things impact disproportionately certain populations within an organization, not just the legal department, although we were the ones who got the training. And having anchored the educational, whether it's a CLE like this or a workshop or training like the unconscious bias ones that MCCA has done over the years, it really provided perspective that didn't exist. Until this day, I'm not really sure if there is a organization that's focused on research specifically for DE&I in the legal profession. So yes, I think it has had a positive impact. Yes, there is a proliferation of in-house lawyers who care about this issue. I think yes, in terms of number of diverse population of attorneys within a legal department, yes. I mean, we're seeing that across the board, and certainly at the top. MCCA has done the Fortune 500 General Counsel research or survey since 1999. So it's been 25 years. So back in 1999, I believe there was one Asian American, one African American, one Hispanic general counsel in the Fortune 500. Today, there are a little over, I think, 80, 90 Fortune 500 general counsel. Don't quote me on the number, because I know we're still doing the numbers for most recent years, but there is a significant improvement. To go from 3 to like 80 to 90, I think that's tremendous progress. And while it can't be all credited to MCCA, but to the efforts of all of us on this call who are committed to this issue, as well as many others who are committed to this work, and to see more equity and diversity and inclusion in the profession, the numbers certainly speak for itself. However, having said that, in the law firm world, that's quite different. Yes, there's been progress. I want to start with the positive, but the progress is, I mean, it's like I think the glaciers are melting faster than the progress in law firms like yours. But there is progress, though. It's moving. It's melting. And certainly, I think we can do more. And like Joe, I mean, it's kind of interesting. I'm thinking about all the backgrounds of the panelists here, and before I decided to go to law school, I was a social worker. I was part of a union, and then I was a plaintiff's lawyer. And really, in the last 30 years, it's been so little on the law firm side. I think it only behooves those who are in law firms, as Joe said, to continue this effort, because the clients do care about it, but it also will impact your bottom line, your revenues, because after all, you are a business.
So Gene, I totally agree. What I've seen. Oh, yeah, a little feedback. Okay. Is that there are a lot more in-house counsel and law firms are dismal, and we say dismal. The last I looked, I think New York, with all the lawyers it has and the law firms, I still think there's less than 2% in law firms of partners. There's still a lot of law firms in New York that have no Black attorneys at all, which is amazing given the demographics of New York and given the makeup of New York. Joe, you mentioned your prior role at Walmart, and part of your job was, I recall, because that's how you and I first met, was deciding what law firms would do work for Walmart. And your general counsel at that time, if I recall, was Tom Morris, who was a dynamic guy, and Tom made it clear that he wanted to see a change. And I remember even before meeting Tom, when I chaired the diversity committee for the Association of Bar City of New York, a general counsel made a comment to me that he had sent a questionnaire out to his law firms about their diversity. He says, Daryl, I didn't get any responses. And I said, I wonder why. They don't have anything to tell you. So tell me this, Joe, do you think, knowing what you did at Walmart, when they talk about affirmative action, they talk about the DEI steps, is it still necessary for corporate America to be a little bit aggressive in seeking knowledge from its law firms of what they're doing and what they're doing in space, particularly given what we all see and what even Gene mentioned about the poor performance in law firms and really increasing diversity?
Well, the expectations that Gene and I just talked about are combined with ever more sophisticated tools that corporations are using to hold their firms accountable. Now, at the core of your question, Daryl, is the why, right? Why was it important? And why is it important to corporations? And by extension, why is it important to law firms? And just looking at Walmart, what Tom Morris, who was, as you mentioned, the GC who recruited me to Walmart, and who I was answerable to when I headed the outside counsel management function, he understood that Walmart's core business relied on growth among certain population bases, right? That included women, that included diverse populations, people who were the core business. And as Walmart looked at its growth, and during the time period I was there, Walmart expanded significantly in Africa, in Latin America, in Asia. And a lot of the people who were expats who went over to help support those businesses were diverse individuals recruited to the company, recruited to the law department. And so at its core, this is about making the business function more properly, making the business, as Gene mentioned, bottom line, expand. And not only that, as Walmart's legal department became more diverse, and as the ranks of Walmart's external counsel became more diverse, the quality of the work went through the roof. You had more responsiveness. You had better quality of work. You had people who, in large firms like yours and mine, Daryl, who were probably underutilized, maybe underappreciated, who perhaps didn't have other large institutional clients vying for their time and attention, when they became the relationship partner for a Fortune 1, they killed it. They knocked it out of the park. They were uber connected, uber responsive, and it gave them more gravitas within their firms, but it also resulted in a better quality, better product for the company. And that's something that shouldn't be lost on any of us.
I agree. So, Nina, there is typically used when they talk about this stuff a term called reverse discrimination. You're a plaintiff lawyer. I can tell you that when I talk to my friends and colleagues who work in the civil rights space, they find the use of the term reverse discrimination repulsive because it appears to create a whole level of standard above and beyond the normal plaintiff case. Is there any justification for the use of the term reverse discrimination versus just it happens to be a person of a certain subsequent classification? So, is there any justification for that term?
I can't think of any justification, Daryl, and I will say this, I can't think of a single case that my firm has taken on with that structure because it's just not, that is not the discrimination that we know and are in the trenches fighting against day in and day out. So I think it's a pejorative term. I think it's a term that diminishes the real discrimination that is going on here against people of color, against disadvantaged groups, against women. It's not a term that I use, and those types of cases are not cases that I am drawn to. And unfortunately, I'm at the point in my life where I get to choose the cases that I fight, the causes that I champion, and they are not among them.
So I know you mentioned the cases you don't take on. I know you're active in NELA. It's my understanding that a lot of the major law firms have made the decision not to take on these cases. Is that true, or am I misled by that?
I can say this. I'm on the board of the National Employment Lawyers Association, NELA, and as recently
I'm
as
sorry, I can't hear
November.
Nina very well, Daryl.
Oh,
And
let me
someone
try.
messaged me
I'm
that they
sorry.
can't hear her very well.
I can't either.
Can you hear me now?
I can hear you.
Better?
Better. Yes.
Okay, let me try this. Okay, I'm going to talk into my phone then because my Wi-Fi wasn't working on audio. So as late as November 2023, NELA promulgated a statement recommitting to diversity and equity and inclusion in the wake of lawsuits and threats of lawsuits against major baseball leagues and Fortune 100 companies and law firms over the diversity, equity, and inclusion program. They publicly reiterated their commitment, stated that it is part of their core values and essential to the achievement of their mission. They encourage their members to continue to do this hard work of fostering diverse, equitable, and inclusive workplaces, including their own. We are working with a consultant now. I am on the committee that is working with a consultant, and her sole function is to help make our policies and practices more inclusive and more equitable, even in terms of who we invite to recruiting members to sit on the board. Because first you have to look at yourself and say, what are we doing? What could we be doing better? We want a diverse population at NELA. We want our board to represent everyone. What can we do in our own backyard? So NELA has hired a consultant to do just that, to look at NELA's policies and make sure that we're walking the walk and that we're talking the talk. So I don't know about, I know some of the major law firms have made commitments not to take on these types of cases. I could just tell you that my personal commitment is we just don't handle those cases. Really, not so much even as a policy, but that we only take on cases we believe in, and they're just not among them.
So, Nina, from your perspective, if employers abandon their internal steps to ensure they are not engaged in discrimination, such as the DI efforts, how do you foresee the plaintiff bar responding?
I think it's going to open a door for us. Ironically, it's going to have the opposite effect. Because if they abandon these programs, or they shrink them, or make them so narrow that they are just not really meaningfully usable. If you eliminate, what the result is going to be, you are going to eliminate key aspects of your population: women, African Americans, disabled people, marginalized people. And what is going to happen is there's potentially going to be then a disparate impact that results, right? If your leadership looks all lily white and male, that's going to be a function of you not having a robust diversity, equity, and inclusion policy. And I can tell you the cases that I've looked at, there's one case out of the 8th Circuit where a female chief probation officer candidate was chosen over a male one. Quite a brouhaha over that. But the court basically said an inclusive recruitment effort enables employers to generate the largest pool of qualified applicants and helps to ensure that minorities and women are not discriminatorily excluded from employment. This not only allows employers to obtain the best possible employees, but it's an excellent way of, quote, avoiding lawsuits. The only harm to white males is that they must compete against a larger pool of qualified applicants. This, of course, is not an appropriate objection, nor does it state a cognizable harm. So I'm seeing here that they do that at their peril. If they shrink these programs, if they do not continue to maintain a robust diversity, equity, and inclusion mindset, they are harming themselves, of course, in their businesses, and we've talked about that throughout this program. They're hurting their bottom line. And they also potentially open themselves to lawsuits. I can assure you that if an employee came to me and said, you know, we used to have this DEI program and it was really great, and we encouraged, you know, and we went out there and we actively sought, you know, diverse candidates. And then not only that, but once they were in our midst, I think as Joe pointed out, we actually made efforts to make sure that they had access, that they were in the game. They were, and that now has changed. I'm going to look at that and say, oh, well, that's a change set in the mindset of the employer. That goes to the employer's intent, potentially to exclude or to hamper or to put behind the starting line these diverse employees. And I'm going to factor that into whether or not I can prove pretext for discrimination, or if they complain about it, for retaliation.
Thank you. So, Carl, you represent the union side. Same question to you. How do you, if employees abandon their initiatives, how do you see the union movement responding?
Okay, so I'd like to make a few preliminary comments. Thank you for inviting me. I'm thrilled to be on the panel with such illustrious participants. And it's nice to be on a panel. I mean, our labor management tends to be adversarial, but in this case, I think at least when we talk about more enlightened employers, at least on this issue, there's much more common ground, which is a good thing. We very much embrace the definition of affirmative action that you put forward, Daryl. You know, it shouldn't be viewed as favoring people with less qualifications. In some ways, I view it as exactly the opposite, that current discriminatory practices and the failure to use metrics that aren't discriminatory leaves talent off the table. And it benefits everybody to embrace that talent. So my firm, for example, we co-partnered with the Center for Constitutional Rights in the case to desegregate the New York City Fire Department, which was the last major city fire department to desegregate. And the key in that case is we were able to show not only a disparate impact of the testing regimen, but that their own experts admitted that the test that was given had little, if anything, to do with what it took to be a good firefighter. So the metrics were changed, and we were able to successfully integrate. You know, now we have a far more integrated New York Fire Department, which is a wonderful thing. So I want to also agree with, well, so to me, it's about changing the metrics, abandoning discriminatory metrics, recruiting more broadly in a way that's not discriminatory. And some of you have touched on this, but retention. The way people are treated once they're recruited and once they're in, not only so they stay, but because of the importance of word of mouth. You know, word will get out among talented people of color about whether they're welcome or not in a given workplace. So all of that said, I think we all need to recognize that the clients we represent, unions and corporations, and it's inevitable in this society, have a history that's been infused with discrimination and racism. Labor unions have an interesting role because while they started out like other institutions as discriminatory and remain so for many years with explicit exclusions of Black workers in many unions, which really, despite a few exceptions, really only began to change in a significant way with the founding of the CIO, the Congress of Industrial Organizations, which sought to organize entire industries and therefore to organize employees who had been considered less skilled, which is where, because of discriminatory practices, most people of color had been concentrated. I think the union movement has come a tremendous distance. So I think you have to look at the fact that right now the labor movement, there are more Black workers in the labor movement than white workers proportional to their representation in society. While there's a burgeoning acceptance and positive view towards labor unions generally, that view is even greater among people of color, because I think, notwithstanding its history, that taken as a whole, the labor movement has done more for equity than virtually any other institution in the country over time because of the operation of seniority systems and other things. Doesn't mean, as in all aspects of society, that there isn't more to be done. There's obviously a lot more to be done. But, well, the other thing is that if you look at those people who are currently organized and unionized, the demographics of the labor movement has changed significantly. I touched on that, but the area which has the greatest concentration are the areas of unionized workers, and where the greatest efforts continue to be mounted to organize new workers are government sector and the service sector, where people of color are disproportionately represented. And I think that is affecting the labor movement as a whole. Now, it's true that there are some sectors, particularly craft sectors, which had a longer standing history of discrimination. And some of the changes, and there have been a lot of changes that occurred in those sectors, occurred for a variety of reasons, one of which was the threat of litigation. One of which was because it was recognized by many people over time with changing values that that was the right thing to do. And some of which was because of the perceived value of integration for organizational purposes. I think that the progress that has been made in those craft unions is irreversible. I think that now that those unions are more integrated than they were in the past, that attitudes have changed within those unions, that as with any form of integration, once you integrate, stereotypes and prejudices tend to dissipate. Not that they don't still exist, but when you deal with people side by side as human beings, your stereotypes are going to tend to dissipate. And within the labor movement, when you have an opportunity to identify with each other over workplace issues and to have a common enemy, use of the term among this population, but a common enemy in the owners and management, then people come to see their commonalities as over and against others in a way, I think, that fosters common purpose and the dissipation of segregationist ideas in a way that's positive. So I think the attitudes of people within the union, both leadership and membership, and the recognition that fighting for desegregation is critical organizationally, and it prevents the historic ability to pit one workforce against another. You know, when the union movement excluded Black workers were recruited as scabs during strikes. And it was understandable that that happened, and it was understandable that people who were excluded from the labor movement took those roles. But now I think, again, the progress that's been made is irreversible. And what I see in my work, I'm exposed to more, but I work specifically with academic workers mostly. And the unions I represent have actively negotiated for changes that facilitate equity and integration. A notable example is New Jersey Institute of Technology, where I represent a large union of faculty members, lecturers, and professional staff. And in the last contract, I'm not sure whether, I'm sorry, I'm getting an echo now too. In the last contract,
can you put your mic on mute right now? Let's see if that can cut back some of the noise.
in the last contract, we did a couple of things. One thing we did, which explicitly addressed equity, was to agree to form a committee to figure out how to investigate and discover where there were inequities in salary based on sex, gender, and race, and to find ways to address those inequities, which gets to the issue both of retention and recruitment. But the other thing we did, which didn't explicitly reference equity, is we negotiated not only healthy across the board increases, many of which were based on dollar amounts across the board rather than percentages, which tends to flatten differences between the lower and higher paid workers. But we negotiated an additional 3.5% across the board increase for any current employee making under $75,000 a year. And we only had the statistics available for women, but that the evidence we had showed that largely eliminated the pay inequities between men and women in the workforce, just that simple move. And our assumption is that it did it between Black and white workers as well. We just didn't have the statistics to bear it out. So I have a lot more I could say. The other unions I represent have at a minimum endorsed and signed on in their collective bargaining agreements to support the affirmative action programs of the colleges and universities where they're located, in this case, NYU and the New School. But I'll leave it at that for now and weigh in later if there are more questions.
Carl, you mentioned, you know, I've noticed during some negotiations, and your firm and my firm do go head to head sometimes in these negotiations, that an issue that's coming up more and more frequently is a question of DEI. Is that going to be something that's going to continue as an issue in the bargaining table? Do you see that changing at all?
Given the changing nature of the labor movement, the fact that it's becoming more political, more progressive, that it has more people of color, I think that it's the right thing to do organizationally and morally, but I also see pressure from below to continue embracing DEI. So I don't see that going away.
Do you foresee any change in how management and unions collectively address the question of DEI and affirmative action?
You know, I think some of that, from my perspective, is up to management and how enlightened individual employers are on this issue. One example I'll give you is I think seniority, well, initially it tended to entrench discrimination. As more people of color came into the workplace, it became one of the most powerful engines for integration and equity. I think one thing that could be done, and I would hope unions would negotiate for, is, you know, so where seniority breaks down still is admission into higher skilled jobs. But the negotiation over training programs with access to those training programs based on seniority, I think is a way, without explicitly referencing race or other categories, that might run afoul of, you know, the law as it currently exists and is being expounded upon by the Supreme Court, would do a tremendous amount to bring more diverse people into higher level positions. The last thing I forgot to say, but I want to say, is I agree with everyone who says that there's nothing in the current Supreme Court decision mandates significant changes in current practices. It may involve some tweaks and changes of language. I think the concern, and maybe the concern among some employers, and maybe rightfully, is we don't know what the second shoe is, what the next shoe is to drop. So there's some hope from the fact that the Supreme Court rejected cert in the TJ case, the Thomas Jefferson case, which may provide another avenue forward for greater diversity. I put a little less weight in West Point just because that was an interlocutory appeal. That case is still pending at the district court, unlike TJ. But I think there is, maybe rightfully, some fear about where the court might go next and trying to protect ourselves from that.
So two things. One, for those who are looking to CLE credit, the CLE code is CLEL001. Once again, CLEL001. Carl, your last comment was actually about where I was going to go next. It seems like a lot of us have agreed that there's been no real change in the law. So the question I put to the full panel, if there's no real change in the law, why are people so aggressively reacting and all across the country? In companies, I've got law firms running into companies. I hear from in-house counsel, they're tired of hearing their outside counsel run in and tell them how, oh my God, it's all changed. You gotta rewrite your programs. Everything needs to be written. Is this all intimidation? Is this firms marketing to make more money? What's going on, guys? What do you guys think about this? Joe, I'll start with you.
Well, Daryl, there's something that Carl said that I really want to drill down on, and it really has to do with putting procedures in place to level the playing field for everyone, right? And I just want to, if you'll allow me, there's one practical step that we instituted at our firm that I want to talk about. I mentioned earlier sort of those choke points where bias can have an impact. The first thing we did, and I think we're the only large firm to do this, we instituted mandatory implicit bias training for all attorneys and staff. We did it live and by video, and we did that in order to sort of create a baseline of knowledge and understanding about this issue. But the other thing we realized is that there was some affinity bias at work in the assignment process within our firm, in the assignment of matters, right? And it was having an impact on our retention of diverse talent. So we created and implemented a blind rotating assignment system in our firm. We implemented it in our trial practice group because that's the largest group and the group where you have the most number of assignments. And it had the effect of cutting diverse attrition in half the first year, and 1 year it was 0. But it also cut attrition among our non-diverse population. And the reason I mention that is because that is something that we did that was agnostic as to race, agnostic as to gender or any other protected category, but it had an impact on our diverse population without specifically targeting by name the diverse population and without specifically targeting people by race. I say all that, and Daryl, you and I have known each other long enough. I know I'm doing a horrible job of answering the question you've asked me, but it's something that I really wanted to mention because in all of these discussions, I think it's important for us to actually look at and drill down on some practical solutions that still move the ball in the DEI space, but are consistent with the law as we currently know it to be.
So you are a classic politician. You get asked the question, you give the answer you want to give and ignore the question was asked of you. So well done in that regard. But you did hit on a very good point. I have no problem with that. But still touching on that point, the question is, why are institutions reacting? And I like your idea. Not only why are they reacting, but what can companies be doing? I mean, if institutions are currently compliant with current law, I like to say there are 3 buckets. There are companies that never really want to do affirmative action, so they're embracing this decision because this gives them legs to justify why they shouldn't do anything that they didn't want to do in the beginning. Companies that are doing everything exactly right, so they don't need, in my opinion, change anything at all. And companies that were a little bit overly zealous in what they were trying to do and need to rein things in so they're not transgressing the law and being exposed. But let's talk about that. What can you guys suggest that can be done by institutions? We have a few questions. We're going to come to those in a second, but what can we consider people recommending clients do? I mean, a lot of this, in my opinion, and Alfonso, I love you to feed it back on this, is a lot of intimidation. I've read some of the legal papers. In my opinion, I've seen first-year law student moot court papers were better than some of the papers I've seen files. What is all this about?
So Gene and I both said this at the outset, and it's a chilling effect, right? But let's be fair. In a lot of these places, all of these places, you have people who have a fiduciary duty to the entity. I serve on the management committee at our firm. Entities are risk averse. and sometimes they need to be risk averse. So let's be fair and say that it makes sense to look at mitigating and eliminating your risk. But once you've done that, you have to be guided by a plain and simple principle. Are you committed to this issue or not? Is there a reason why diversity, why equity, why inclusion and an inclusive environment is important to you? And if so, what you should do is to continue doing what you're doing that's compliant and look for ways to expand your opportunities to create a diverse workplace, right? Casting a broad net, making sure that you go beyond the usual areas when you recruit, making sure that there is equity and fairness about the recruiting process, about the assignment of work, the evaluation of work. MCCA has a whole wealth of research reports about how to make sure that there is equity when it comes to the evaluation of work. Even how and when and under what circumstances people are separated from the organization, making sure that there isn't bias that has a negative impact disproportionately on people of color. These are all things that you can do that comply with the law and that are on their face agnostic as to protected categories, but really inure to the benefit of the whole.
Yeah, I would echo that, and just following up on that, you know, the whole piece about assignment systems. I mean, that's based on the research actually Joe and the ABA led prior to my time. And what we have done is to really disseminate that over and over again, even though that was, you know, started in 2015, we're still talking about it, but the benefits of that are things that people should really be embracing that is race neutral. So the assignment system, it's actually really interesting that you mentioned that, because we have revised, updated toolkits and services as an organization to really help people think about retention in a way that is race neutral, that can have positive outcomes for everyone. Because one of the reasons why people are suing and these sort of, I don't like the term reverse discrimination, but all of these cases about discrimination is the notion that somebody's getting something that they don't deserve, or somebody's getting something that you feel like you deserve. So in order to minimize that, you know, one example that Joe used is the assignment system. How can we ensure that everyone gets an equitable opportunity? Because at the end of the day, that's hopefully what's going to satisfy those who believe that they're getting discriminated against, whatever side you're on. And if it's a policy or a process that's fair and equitable, and you're giving an opportunity to everyone, there's less chance that somebody is going to say, hey, I'm not getting something that somebody else is getting. And again, it's all based on the research that that was done by the ABA, and certainly when Joe was here at MCCA as its CEO. And those are the opportunities, those gatekeeping functions that I think everyone referred to at the outset, where you can start to make some significant changes to continue to have representation. Because again, you know, you're serving a diverse population of people, and Walmart is a great example, as well as many other businesses. If you're expanding in different parts of the world that is not homogenous, the way you believe it should be within the United States, although I can't imagine too many places that are that homogenous here in the United States. There are some, of course, but where most of these global companies sit, there is a lot of different population of people. And if you're serving a certain segment, you need to have those people represented within your workforce. And it behooves us to think about what the workforce will look like. And I'll just end with this. One of our board members mentioned a CEO call where an activist investor said, you know, I don't want you to focus on DE&I. And the CEO's response, and I'm just going to quote it, paraphrase it, not quote it, but he basically said, DEI is my growth strategy. So unless you don't want more earnings per share, come and talk to me. So, because this is the population, this is the area that we're growing, and that's why we're focused on DE&I. And I thought that was a fantastic response, which is why I should really get the exact quote so I do him justice.
Gene, you did a very good job with the quote. Nina, you had your hand up, so I'll let you go now, Nina.
Yeah, you know, I will say this. I don't think there's really paranoia here. We've seen what's happened lately with the Supreme Court and how quickly it's trickled down and impacted all of us. We've seen the Cummings versus Premier Rehab decision that came down just before Dobbs, this little known decision that turned my world upside down. It was an Affordable Care Act and rehabilitation decision that said the plaintiff wasn't entitled to emotional distress damages because those statutes were founded under the spending clause and therefore they only got contract damages. That trickled down to my Title IX cases where I recovered $2 million for a woman 2 or 3 years ago before the case came down, who was raped in the workplace, and she came to me under Title IX, not under Title VII, because Title IX has 3 years. Title VII only has 300 days to sue, and took her a while to come to me. And now those cases are moribund out of a Supreme Court decision that had nothing to do with Title IX. All over the country, the circuits are falling into line and saying, oh, Cummings. It applies now to Title IX. So I wouldn't be surprised. I don't think we're being paranoid and being concerned about the impact of this Supreme Court case. I think we're being realistic and we're getting ready, and we should get ready. And there are good underpinnings that SFFA is not our case. It's not a Title VII case. We've got United States Supreme Court decisions that support race-based employment decision-making under narrow circumstances. United Steelworkers of America versus Weber. We have a case that supports United States Supreme Court case that supports the agency appropriately taking into account the sex of the female employee in determining whether she could get the promotion. Johnson versus Transport Agency. We have cases, but then again, I had a Supreme Court case underpinning for my Title IX case that I cited, and it died on the vine because of this Supreme Court case that applied to other situations. So I don't think we're being paranoid. I think we're being smart. I think Jean is absolutely right. The idea is let's broaden the definition of diversity. The broader we make it, because it can go obviously beyond race, ethnicity, sex. It could go to geographic location. It can go to languages that are spoken. It could go to parental status. There can be a broader tent. And again, that only inures to the benefit of all. Let's get all qualified applicants in. Let's get all people working for us so that we can reflect the community that we serve. And the broader we define diversity, the better chance we have of not being subjected to this scrutiny. But I am concerned about this decision. I think we have good arguments, but I think we're so smart, and I'm so grateful that so many people today came to listen to this program when it doesn't immediately affect us at the moment, because we're recognizing that it's imperative that we get ahead of this and start thinking about it, start planning it, and start putting the seeds in the minds of employers about what they need to do to keep moving forward and not take a step back for fear that this is going to come back to harm them. Because I think when all is said and done, what is going to happen here is that those employers that do not embrace the moment, do not continue along the same way, but maybe do it framing the issues differently, as Jean Lee described, is going to be absolutely imperative that we keep the foot on the gas and keep on and dispel the fear mongering and all of that, and just be smarter about the way we do it, so that we don't get caught in this trap that potentially could be SFFA.
So I want to give both Carl and Alphonse a brief response into it, and then I want to go to the questions that have been sent in.
So thank you. A couple of things quickly, micro level and then macro level. On micro level, thinking about law firms and hiring generally, I think it's going to take more time. But I think if we look at hiring in a more micro level, if we evaluate people's qualifications individually, it's easier to recruit and justify recruitment of a more diverse population. Another interesting thing that was raised at the presentation I gave at the Union Lawyers Alliance in Minneapolis last week was this: our firm assigns associates both supervisors, and mentors. But it was raised that you can go a step further, that some firms and companies are assigning sponsors whose job it is to specifically advocate for people that they're assigned to. And I think that can be very useful in helping people move through an organization if they might otherwise be marginalized. In terms of obstacles, there's this tension as I see it between what's good, what we perceive as good business, especially if we have diverse clientele, and fear of consumers, which has been raised, and it addresses one of the questions in the chat of companies being attacked for embracing DEI. And I think fear of litigation is an issue. Even if you win the litigation, it's obviously expensive to litigate. You don't want to do that anyway. But I would, piggybacking on Nina, I think it's really important that all of us and the companies and unions we represent don't cede the rhetorical ground, that we're out there making it clear to the public and to our own constituents what affirmative action really is, what we lose by way of talent by not embracing it, as well as why it's wrong, morally and for other reasons.
Carl, I got to just respond to one thing. You mentioned it takes more time. And I've been practicing, I think you said something about it takes more time. I've been practicing for over 4 decades. I've been having this conversation about diversity in the legal profession the entire career. We all get one lifetime, all right? And we have one lifetime in our careers. And, if I've been doing this 45 years in the same conversation, the likelihood is how many lifetimes we have to go before we make actual change. There was a comment made in the SFFA case about the concept that Justice O'Connor said in 25 years, as though the 25-year mark was some kind of magical thing that in 25 years it all changed. The tragedy is, despite the passage of 25 years, there was almost nothing that had changed significantly enough that it still needs to have this address being concluded. All right.
You misunderstood me, Daryl. I apologize. But I was just saying that the hiring process itself is more labor intensive if you look and drill down on individual clients, individual applicants. That was the point I was making. It was worth spending the extra time. But then you could embrace, John Roberts' caveat in the SFFA decision, for example, where you can look at what is an individual's experiences, what have they overcome, and how does that speak to their qualifications?
Alphonse, do you want to add anything in before we move to the questions?
I'll just say I concur with my fellow panelists. I'm on mute.
We can hear you.
Now you're fine. Now we can hear you.
Oh, you said I was on mute. Okay, sorry about that. I would just say I agree with my fellow panelists here. There's one point that I think a few folks have touched on, but I think is worth refining or going into a little bit more detail. There is a fundamental difference between affirmative action in education and affirmative action in employment or contracting. Mm-hmm. And we don't often talk about it in that way, but I think it's important to. So most people may know, in education, affirmative action had historically permitted colleges and universities to consider a person's race as one factor that determined who did not or who did get into a specific school. By contrast, affirmative action in employment has always prohibited any consideration of race in decision-making, such as who to hire or who to promote. Instead, affirmative action in employment means that an employer commits to act affirmatively to support and encourage diversity in the workforce, such as fostering a work environment that celebrates differences and is welcoming to all. That's what affirmative action means in employment, which is why I think it's really important as we talk about the narrative and the language that we have to highlight the fundamental distinctions between the two. And the misinformation that we're seeing out in the public sphere and in the courts has been to try to conflate the two. Exactly. And I think we have to make sure that we keep those two concepts separate, because the case law is different. The regulations are different. The statutes are different that govern those two principles.
100% correct, Alfonso. So let's go through the questions real quick. What about woke attacks from the right? Institutions have been fearing the negative publicity. Is there an ability to push back? Any thoughts, guys?
I'm sorry, is there an ability to push back?
Yeah, in other words, obviously everyone knows that there's a lot of negative. You got the certain attorney generals in certain states sending letters. You've got people coming up and threatening. You got some what you call shareholder attacks, attacking the woke movement, claiming it's woke because we're trying to do EDI, and that puts some companies in a position where they, in fear, try to regress. What do you guys think? How do we push back on that?
Well, I would take a stab at that. It's fascinating to me that we're having a conversation about business leaders being attacked for running their businesses. Many business leaders who run their businesses ostensibly would subscribe to a free enterprise construct, right? We live in a capitalist country. You run a business. Most folks would say you should have the right to run that business consistent with revenues or your mission or your profit margin or whatever the goal is. What's interesting here is you have those who have been subscribing to a free enterprise concept attacking it in this case. They're saying to business leaders who are embracing diversity that as a matter of law, they should not. And we know that there is no federal statute that essentially says private companies have to hire a certain amount of women or people of color. It doesn't exist, right? Private sector companies have been embracing diversity through a defensive lens because they're concerned about potentially getting sued for a lack of diversity. But there's no statute that essentially says they have to hire a certain amount of people. There's no quota system. So there is a free enterprise component to this that I think employers need to embrace a little bit more, especially given Carl's earlier point, and I think Joseph made this point as well. We don't often talk about the data. The data clearly shows that there is a direct benefit to diversity. Companies that embrace diversity actually perform better. Companies that embrace diversity are more innovative. Companies that embrace diversity are the companies of the future. So that is the response to someone attacking a corporate leader about why his workforce is diverse. My answer would be because I want to succeed. I'm not hiring Black and brown people as a token. I'm hiring them because I know I will have a much more successful company as a result.
Daryl, I could not agree more. It's with data. And I mean, look, I think about two things. There's a study that was released in September of 2020 by Citigroup called The Cost of Racism. And if you just Google Citigroup, The Cost of Racism, you'll find it. What the study revealed is that over the first 20 years of this century, between 2000 and 2020, the US lost 16 trillion in GDP because of systemic bias against African Americans in just 4 categories: wage and income disparities, lack of access to educational opportunities, housing discrimination and redlining, and the lack of access to equitable and fair entrepreneurial opportunities. So that's just discrimination against Black people in just 4 different areas. 16 trillion in GDP. Now, if those barriers hadn't existed, would Black people have benefited? Absolutely. You know who else would have benefited by 16 trillion in additional GDP? Everybody. Exactly. Everybody in the country and arguably everybody in the world. I mean, 16 trillion with a T in GDP, that is significant. You know, Heather McGhee's book, The Sum of Us, if you haven't read it, The Sum of Us, What Racism Costs Us All, has some startling anecdotes in it about exactly what you described. Some of these wrong-headed policy decisions, like, for example, shutting down public swimming pools back in the 60s because they didn't want to integrate the pools. They didn't want Black people to go to the pool. And then you had whole communities that went decades without public swimming pools for anybody. I mean, it's just, you know, if you think about the fact that every organism on the planet is motivated by self-interest, and to the extent you can use data to get people to see how it is in their own self-interest to be fair and equitable to everybody, I think that's one really persuasive way to finally, hopefully, get people to understand the value of diversity.
I think it's real important that we understand history, and I think people don't want to go back and remember history. That's why there's a lot of attack on the woke movements, because woke movements is really about making sure everyone understands from where we came. I mean, it's interesting that we're talking about this subject. Friday will be the 70th anniversary of Brown v. Board. And it's tragic that 70 years later, we're still talking about this. My firm did a program last week with one of the Little Rock Nine, and she talked about the experience she had as a student going into the school in Arkansas. And as you guys know, to your point about the pool closing, in response to the integration in Arkansas, they closed the high schools for a year and hurt everybody.
Everybody,
It's cutting their
yeah.
nose to spite your face. It's the same mentality.
Well,
It benefits
the other
society
thing
by educating themselves.
Well, one other thing I'll say, and Gene made reference to this, the way that they've co-opted the nomenclature, where all of a sudden DEI is a bad word, or woke. I mean, if I call an Uber and I get in the back seat and I look in the front and my driver's falling asleep, what's wrong with being awake and woke and conscious and aware of your circumstances? And I think that's the other thing we should resist. I mean, Gene, I know a lot of entities, to your point, that have decided to change what they call DEI. We've resisted that because, we're reclaiming the nomenclature, reclaiming the language, because what we're focusing on, we want a more diverse workplace. We want it to be equitable. We want it to be inclusive. And so for me, I look forward to when the pendulum swings back and there's some normalcy back in this space. I'm not going to hold my breath, but I really do think that because there is an inevitability about both the demographics in this country and also the through line between the growing demographics and the growing savvy of the workplace combined with expectations of the corporate space, I think we'll get back to the point where people realize the value of DEI and stop pretending like it's a bad thing.
Well, one thing we talked about this earlier, Joe, before the program started. What a lot of companies and even law firms have to do is they have to have DI people who understand what they're doing. And I think too many institutions are making their DI person someone from public relations and marketing. So they're really doing a sales pitch about, look what I'm doing, aren't I doing a great job? And then really doing nothing to really promote DEI. They're just making the firm look like it's promoting DEI. And that can create more problems.
Post George Floyd, there were a lot of organizations that really hadn't thought this through, that just grabbed any person of color and put them in place. And I mean this with all due respect, but it's like any other aspect of your business. It has to be thought out. There has to be an infrastructure in place. There have to be resources put into it. And there has to be a connective thread to the bottom line of the organization. And if there's not, it's doomed to fail. And you put people in a position to fail if you don't provide that support.
Do you guys think there'll be there's been a recent Supreme Court decision expanding what might be covered by Title VII claims, the module decision? Do you guys have any thoughts about whether or not that changes any of the dynamics of this analysis of what we're having a conversation on? Nina, what do you think? You're a plaintiff lawyer. You're mute. You're on mute. Nina, you're on mute.
It would not be irrational to expect that such a decision is in the offing. It would not be, just based upon the progression that we have seen. And, I completely agree with all of the sentiments that Joe has expressed on this topic and the mindset we have to have. And I think even if they do come down with a decision, we still can use these same concepts that we've talked about today to thread that needle and continue these initiatives.
So, guys, I want to give each a chance to do a wrap up. We've got 5 minutes left before our period ends tonight. We've got 6 people. But, given the fact it seems like we're saying the law has not changed, given the fact it seems like, and if anyone disagrees with me, we're saying that discrimination still exists in the live well America, as demonstrated by the recent New York Times study showing that a person who has an African sounding or black sounding name has a less likelihood of getting a job than a white individual. The fact that they still show studies showing that a white individual who has a criminal record is easier to get a job than a person who's a black person without a criminal record, showing discrimination still exists. What is it, any last kind of comments of what you advise both law firms, corporations, anyone who's listening to this phone regarding the whole challenge, the SFFA case as it applies to the employment space? I think we're saying don't panic, don't worry, case course, but yes, make sure you're in compliance with the law, doing it correctly. But if anything's wrong about that, please give me your perspectives. I'll do a reverse when you did. So, Carl, why don't you start from that end? You saw the last one speaking before.
Sure. So I think Joe's right. I think we're all right that DEI is in affirmative action is in, the interests of business. It's in the interests of labor. It's in the interests of the nation. But I'll speak to, no pun intended, the elephant in the room here. A lot of the attacks on DEI are not motivated by rational positions. And corporations are being attacked and boycotted when they take DEI positions by people who embrace racist ideology. And I think when people look at short-term gains, they're afraid. And so I would urge all of us and all of our constituents to take the long view. In the long view, if we have, an ultra right wing or even fascist government and a resurgence of racism, that'll be bad for us as human beings, and it'll be bad for business in this country. Certainly it'll be bad for labor. So I think we have to take the long view and really embrace the rhetoric, not just continue doing what we're doing, but publicly embrace it and try to redefine the terms from what the public perception is and try to galvanize a coalition around it.
Nina? You're muted. Mm-hmm.
Sorry about that. I mean, I remain cautiously optimistic that DEI is here to stay, that we've laid a significant enough groundwork for it, that it's not going to be completely dismantled, that we just have to be smarter and use, I'm looking at Justice Roberts' words, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it discrimination, inspiration, or otherwise. I think we have to find ways to be smart about how we frame it, so that we frame it with a big tent and we frame it with, as Carl mentioned, being thoughtful about how we hire and the questions that we ask, and maybe training our children and our, the people that are going into the workforce about how to present themselves in a way that talks about the whole package that they bring to the table. Because isn't it amazing the fortitude and the strength and the desirability of a candidate who has overcome significant obstacles in their lives? Doesn't that speak to their tenacity and their ability to be successful in any kind of challenging environment? So I think we have to attack it at all angles, and just continue to have this kind of like conversation bubbling up. Any opportunities that I have to speak to SHRM or to organizations, sometimes I'm asked, to speak to the other side, to let them know what they can do to avoid, encountering me at the other end of the table. Well, one of the way you can do that is by certainly walking the walk and talking the talk, and continuing these efforts, even in the face of these recent setbacks. And they're not setbacks yet, but they potentially, as we discussed, could be.
Jean?
I wanted to like almost give Joe a high five, or want to have like those emojis that did the clap when he was talking about the challenges. Why some of the challenges, I think they're self-made and self-created, because corporations, like what they're doing exactly now, and many employers. So I don't want to just focus on corporations. Everyone is kind of running around trying to figure out what they aren't allowed to do. And I really appreciated Alfonso's definition of what affirmative action is and is not in corporations, and then comparing it to the educational institution as well. I think that needs to be reminded and almost kind of established as a headline for a lot of these discussions, and start from that point, because having inexperienced people do DE&I, not understanding what affirmative action was for corporations, and then not getting the appropriate advice, I think just created a recipe for all that's sort of happening, this chaos. And I too am waiting for a time where this will settle a little bit and the pendulum will swing, hopefully back somewhere in the middle, and not these extremes that we're seeing now. from the right, if you will. Having said that, I do think that it takes all of us to continue this effort. You mentioned about how this started, many decades ago for you when you started out practicing law, and really hasn't changed much. So I'm not really sure why some are claiming that these diversity efforts are negatively impacting their lives, because it really hasn't changed much. And if you are kind of an investor, it's a poor investment strategy, because the growth is like minimal in the last 30 years. But I do think there's more growth ahead because of the changing demographics that many of you referenced. The world is changing, the businesses are changing, and if you are trying to stay ahead, it's important for you to think about how you're going to be consistent as a business. I mean, if you look at, there was a report, I think it was Just Capital or McKinsey, one of these organizations, millennials and Gen Z especially, I mean, that's the biggest population of investors in the next 20, 30 years. And Gen Z especially care about these issues and where companies stand on this issue. So if you're a corporation that's going to swing one way and swing the other, because you have a couple of these lawsuits that are in some cases, really noise than anything else. I won't speak about the merits because I'm not an expert in that space, but it seems like noise. It doesn't seem like, if it doesn't pass the sort of the smell test, if you will, you have an opportunity and an obligation to stand up, because that will speak volumes for your future generation of workers, investors, and the like. And so I would ask that all of us think more proactively about the future rather than reacting to what's happening, as Joe and Nina and Alfonso and certainly Carl and all of you have mentioned. I think that's where we all need to come together and to really stand our ground. And I think with that, there should be some progress forward despite all this noise. So thank you again for having me.
We're pushing over time, but Joe, and anything you want to add in?
Yeah, just real quick. I was thinking about the video that went viral at Ole Miss, the young man who was taunting a Black woman by making monkey sounds. And it occurred to me right there at that same campus 60 years ago, some of the people in that audience, their grandparents were probably, trying to keep James Meredith from integrating the University of Mississippi. They were on the wrong side of history then. If they could go back in time, I'm sure they would do things differently. I think people who are attacking DEI now, I mean this sincerely, are really going to be on the wrong side of history, because our country relies on a strong, solid, expansive, diverse workforce and an equitable workplace. And that's really all DEI is about.
Alfonso?
I would just say that I would encourage us to think about this issue through the lens of KPIs and P&Ls. Businesses are in business to make money, so we have to acknowledge that. And we also have to appreciate that diverse human capital is an asset. So when we talk about assets that companies have, if those assets are being attacked, companies don't step away from valuable assets. Diverse human capital is an asset that companies need to support, even though they're being attacked.
I close by saying a lot of companies have created what they call future of work teams, looking at how the future, part of the future work teams touches on what Jean Lee pointed about, the millennials, the Z generation. That has become a very big issue where people want to be able to work at a place, demands of what they want the companies to be speaking issues and representing the issues that they're concerned about. So if companies are paying attention to all this stuff, I think DEI is part of the equation. We're not going to escape this, and I think you're right. Being on the right side of the history, Joe, is exactly what we want to be. I want to thank my panel. For the people who had CLE issues, again, the code is CLEL001. Again, that's CLEL001. Again, thank you, each of you coming. Thank you, the audience, for listening. Have a great day.
Thank you, Daryl.